Okay, so let's get into this. Basically, I had another interesting conversation with a veteran who basically, came from the VA side, 100% P&T, 100% TAU, all that jazz. And the bottom line was that the veteran was saying, well, what is the duty that the SSA has to assist with the claim? Because, the VA has a relatively well established and strong duty. It goes way, 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 way back to like the time of the settlers of the United States, where these colonial individuals were actually protecting those who were assisting them in protecting the little colony and being active in warlike duties. So I said to him, I said, look, the has a standard. The SSA has an actual written out standard, but the duty to assist, the duty to do this, the duty to that, it's not just not as strong as the VA. And, the person was like, I don't understand why. I mean, they should have the same level of duty that the VA does to go ahead and assist with developing the claim and doing this and doing that. And I was like, man, you gotta understand the VA, like they take their claimants, their veterans, and they have all these amazing programs and all these amazing, things after you're basically found disabled to make sure that this happens and that happens. And I said, they've got the whole, from start to finish options available. Where most veterans, kind of don't do well with it is that they'll start something but then not finish it, and then that adds evidence to whether or not they can take them to the next step. So we start talking about these differences between the duty to assist, where what is the SSA's duty to continue to assist individuals when it comes to their claim. And so this video is not a comparison of the duty to assist. I'm just trying to show you guys in this video what the SSA is required to do. And then in 2017, remember Commissioner Saul era, what their interpretation of that is, because they literally released a writing on it to kind of spell out what they felt they had to do. So let's go into this real quick. There's this rule, section 404.1512. Again, section 404.1512. If you go down to basically section B, our responsibility, right? So it's their responsibility. Number one, develop before we make a determination that you are not disabled. We will develop your complete medical history for at least the 12 months preceding the month in which you file your application, unless there is a reason to believe that development of an earlier period is necessary, or unless you say that your disability began less than 12 months before your filed application, or sorry, you filed your application. We will make every reasonable effort to help you get medical evidence from your own medical sources and entities that maintain your medical sources evidence when you give us permission to request the reports. So, big thing number one, they'll go out at the initial filing level, not all the levels, but at the initial filing level, and basically buy the medical records for you. Now, the SSA over time has become more liberal and accepting of buying medical records at the administrative law judge hearing level, at the appeals council level. And the reason why this is that many of the SSA judges don't want to have to send out subpoenas to basically these medical facilities. And so the deal is this: we as attorneys, if a facility won't send us the records, we go to the federal government, we file an HHS violation, and then we go to the SSA and we go to the judge and we say, Your Honor, would you please submit an 827, their HIPAA, to that medical facility? And if that doesn't work to obtain the medical record, would you please then follow up with a subpoena? And they just, most administrative law judges don't want to have to go ahead and submit a subpoena to a medical facility. They're getting better at it. But the bottom line is, usually with an 827, the medical facility will send it to them because it's the federal government requesting it. And that's, they know that the follow-up with that is going to be a subpoena where, they'll have to answer specifically why they're unable to send the records in. If the answer is not good, then a U.S. Marshal might show up to go ahead and say, where's the medical records? Now, so bottom line is this subsection B, right, 404.1512 tells you they've got to basically get evidence. Here's the subsection 1 of that, right? Every reasonable effort means that we will make an initial request for evidence from your medical source or entity that maintains your medical source's evidence. And at any time between 10 and 20 calendar days after the initial request, if the evidence has not been received, we will make one follow-up request to obtain the medical evidence necessary to make a determination. The medical source or entity that maintains your medical source's evidence will have a minimum of 10 calendar days from our follow-up. Okay, so here's the deal. Request to reply. Unless our experience, the SSAs, with that source indicates that a long period is advisable in a particular case. So what they're really saying here is, okay, they're going to send out a HIPAA, an 827, and then they'll give a little bit of time. And then basically they'll send out another request, right? And they'll give a little bit of time. But that's what their duty is. It's not a super high duty where they have to, for most part, send out a subpoena and go after them, etc. Now, with that said, we still request from the court that they send out a subpoena when it's at the ALJ hearing level. But when it's below that at DDS will usually fail and then not be able to go ahead and have recourse beyond that. Now, an additional thing to know is that they've been working on this system, which is kind of like the criminal system, where like all of your records are for any jail time or prison time that you might have sent. They go to one particular place for the state. They click, log in, and boom, they can pull your criminal records. Well, they didn't really have something like that for the longest time for the medical record system. But now a lot of medical facilities, especially the larger hospitals, are all on the same network with medical documentation. So they can log in, do a request, and then boop, almost instantly get some of the medical records back, which is very, very good. And that's what they're working towards with medical records. Now, with that said, I'm going to read to you the part 2 here so you understand it. And then we'll go into the policy interpretation that they did over here in 2017. Part 2. Complete the medical history means the records of your medical sources covering at least the 12 months preceding the month in which you file your application. If you say that your disability began less than 12 months before you filed your application, we will develop your complete medical history beginning with the month you say your disability began, unless we have reason to believe your disability began earlier. If applicable, we will develop your complete medical history for the 12 months period prior to the month you were last insured for disability insurance benefits, the month ending the 7-year period you may have to establish your disability, and you are applying for widows or widows benefits based on disability, or your month you attain age 22, and you are applying for child's benefits based on disability, right? Because they're looking at disabled little child benefits there, because between 18 and 22 is, the traditional where you have to show you were disabled. Now, with that said, right, what you should take from that paragraph is that they'll go back 12 months from when you file or when you say you likely became disabled. But they're not going back they're not going back 5 years. They're not going back 7 years. They're not doing that degree of going backwards in time to try and obtain those records. And most of these medical facilities will only retain records for 7 to 9 years, and then basically they get rid of them. Now that's changing because a lot of them don't want to spend the time to hire somebody to go into the digital system and delete the records after a certain amount of time. But, as memory, right, in a computer, like how much storage you can have, as memory becomes cheaper and cheaper, I can almost bet you that they'll just keep medical records like forever at that point. Because, remember back in the day, they had these giant sliding walls. And then like all of your files would go up onto this giant sliding wall. It's like an actual paper file. And you just have a bunch of administrative people running around grabbing files from it, and then sending them through the fax or creating a copy, and you go pick it up and blah, blah, blah. It's not like that anymore. Now they're digital records, and the only real resource limitation was essentially how much could you print and send. And then also the resource limitation was, how much could you go ahead and store in these computers. But now that we have like, gigabytes upon gigabytes, I think in the future, probably in 10 years, what people actually do thing will be just keeping the records for the rest of the time. However, and I want to point this out, and I think this is important, keep in mind, they sometimes don't want to keep records past that 7 years or 9 years, depending on what their policy is at the hospital or what the state requires. They sometimes don't keep them for a longer period because the thing is, when somebody requests them, and they have them, they're supposed to respond with them. But if they don't have them, they can't send them. And if they can't send them, right, then if the person's saying, well, I was injured by that surgery with that doctor at your hospital 7.5 years ago, I need my medical records. They can respond and say, we don't have those medical records anymore. And then that it is what it is. You either had a copy or you didn't have a copy. Now, there's a statute of limitations with that, with filing suit against a hospital, but some states have it so that, basically when the medical issue arose, right, you didn't realize it, and then all of a sudden, oh my goodness, they found a glove in my stomach from when they did that surgery. Then they can go ahead and begin the suit way down the line. Now, that's an obvious example where you had a surgery, it ties to that hospital, et cetera, et cetera. But there's other examples where the hospital would get away with liability because nobody had the medical records to show what actually happened. So that's just a down the road winding kind of thing. All right, now here's the thing. I want to go through specifically over here what the policy interpretation was related to this particular rule. Let's go through it real quick. It was Social Security ruling 17-4P. Okay, this is for Titles 2 and Titles 16, which just means SSDI and SSI, Social Security Disability Insurance Benefits, regular disability benefits, and Supplemental Security Income Benefits, your SSI or your Poverty Disability Program. Here we go. Responsibility for developing written evidence, because there was an issue here as to to what degree does the SSA have a responsibility for developing written evidence. So this was effective on October 4th, 2017. This was during the Commissioner Saul era. It was Federal Register Volume 82, number 191, page 46,339. Let's get into it. Purpose. This ruling clarifies our responsibilities and those of the claimant and the claimant's representative to develop evidence and other information in disability and blindness claims under Titles 2 and Title 16 of the Social Security Act. This ruling applies at all levels of our administrative review process as described below. So, bottom line saying, this is it. This is how we're doing it. You don't like it? Tough. All right, let's go through real quick. Introduction. We need complete evidentiary records to make accurate, consistent disability determinations and decisions at each level of our administrative review process. Cool. So they basically need a solid record to figure out whether or not you're disabled. Although we take a role in developing the evidentiary record in disability claims, claimants and their appointed representatives have the primary, you notice that right there, have the primary responsibility under the Act to provide evidence in support of their disability or blindness claims. So a standard of a primary versus secondary is being established here, right? Consequently, we expect claimants and their representatives to make good faith efforts to ensure that we receive complete evidence. Under the Act, we cannot find that an individual is disabled unless he or she furnishes such medical and other evidence of the existence thereof as the Commissioner of the Social Security may require. So you see real quick this duty to develop. The VA has a duty to develop that's very, very strong. They're like, we will go get your evidence, and it's like, very strong. And the thing too is with a lot of VA people, like a lot of the medical evidence is directly, it's in the VA. Like a lot of them get their free medical care from the VA. And then, the ones that realize the VA system doesn't have the best medical care system, they'll go out into the private market and keep getting medical care. But, so it's easy for them to get the evidence because it's right in-house. But their standards of how they would support an individual, a veteran, with their disability claim thereafter, way higher, like super, super, super higher. So, all right, let's go through this real quick. I see Diana Fernandez and Marjan. Very cool, very cool. Deb Lindy, Lindy, how we doing? Very good. So real quick with this thing, this statutory provision places primary responsibility for the development of evidence on the claimant. I think what's interesting about this is that it took till 2017 for them to really, really tighten down on saying or having a way out of saying that the primary responsibility of getting evidence is on the claimant. Because there was always flickers of it here and there, right? In rulings from judges or this or that or blah, blah, blah. And the way, everybody kind of just looked at it was at the initial filing and recon levels, they would get the records at the ALJ, and up level, administrative law judge hearing level, OHO, but back then it was called ODAR, would basically, the attorney would just go get the records. And so the thing was like when people didn't have an attorney that were going to a hearing, it would put this burden on the hearing office to create a list and then send that list to DDS and have DDS go and collect the records. So what's interesting about this is that this is their way of coming out and saying, hey, at the end of the day, we'll try as the SSA, but we're, you're the primary responsibility. We're secondary as the SSA, but the primary responsibility is yours. That's on you, So that's what this writing in 2017 is about. This is another one of those evidence things where you read it and you're like, oh, cringe, because you're like, government, come on, we pay into this, we pay for this our entire freaking lives that we're able to work, and then it's like, they come out with well, we'll help you out, but you know what I mean, it's your gig, You know what I mean? And so my interpretation was that, the claimant always has a duty to tell them where they've been for medical, like no matter what, because otherwise, how the hell are they going to know? We don't have a system set up yet where like every single medical facility, little ones, big ones, all that stuff, has like a perfect database somewhere magically in the cloud where we can just like put your name and put your social and put your birthday in and poof, we can grab the records. Like that doesn't exist. So, there's always this. And I mean, once that does exist, they'll have to do a policy rule change. They'll have to do a change. And they're getting closer to that. The big hospitals are doing that now. They have a shared server system. But the thing is this, like, and this is really what you have to understand with this whole situation. The SSA is constantly writing themselves out of having a duty to do something or clarifying with a policy interpretation that at the end of the day, they don't, you know what I mean? They're the secondary on this whole situation. They'll follow it, but really it's your job to get it done. So here, I'll give you some more of this jazz. Here we go. Consistent with the claimant's statutory obligation to provide us with evidence regarding his or her disability or blindness claim, our regulations require a claimant to submit or inform us about all evidence known to him or her that relates to whether or not he or she is disabled or blind. Now, remember, part of that is right there that, because they don't know where you go to medical and stuff like that. What they're really saying with that whole situation is, if you don't tell us that you went to that medical facility 2 years ago and that you had, potentially narcotics in your system, we wouldn't know unless you told us. And it's your primary responsibility to tell us, because some people know to play the game there. Like if they're like, okay, well, when I went to that hospital, I did have, this in my system. And then they won't tell their disability attorney and they won't tell the SSA. And then that evidence never goes in. And then boom, there's nothing on the claim that says, hey, they were using and abusing. So there's that side of this too, that they're saying, you have the primary and you have to tell us where, all the evidence is so we can go get it. Because otherwise we can't develop a record. There's a bit of that going on here with this. Next thing. At the hearing level, a claimant generally must submit or inform us about written evidence at least 5 business days before the date of his or her scheduled hearing. We adopted this 5-day requirement in December of 2016 and implemented it in May 2017 to address unprecedented workload challenges. So this is a rule, just to clarify real quick. A lot of people were going into the hearing and saying, Your Honor, can I have an open record of 20 days? Your Honor, can I have an open record of 30 days? Your Honor, can I have an open record of whatever? And the judges were like getting pissed because almost every hearing, well, not almost every hearing, but a lot of them, everybody was requesting an open record. And that's because the medical facilities were being little shiitake mushrooms. They were not being helpful individuals when it comes to sending out medical records. So they were fighting us and these medical facilities, and there was this whole, policy interpretation problem as to what HHS, Health and Human Services, said about, high techs and how high techs, which is, requesting records digitally, should be used and how much it would cost, because back in the day, people would use standard HIPAAs. And, if you had a 500-page record, you're paying $550 for shipping, handling, the box, all that crap for them to send you 500 pages of medical records, which is insane, right? And then the disability attorney would have to cover that until basically the decision was made on the claim to be found, fully favorable, partially favorable, or unfavorable. And so if the disability attorney took on a claim and had to, represent the person for all that time, and then on top of that, get hit with all the medical record costs of an actual HIPAA, like let's say a record had like 5,000 pages. Happens. It's not all the time, but let's say like 1 in every 200 claims has that, right? Then the attorney, if they're buying the records, right, they're putting out like 5,000 plus, 100 and something dollars for shipping, handling, and the box and blah, blah, blah. So automatically, like, the claimant is supposed to pay essentially the disability attorney back once they're found disabled. But this huge problem was that the claimant would get paid their back pay. And let's say that they only ended up getting paid $3,000 worth of back pay. Well, then they wouldn't have the money to pay for the medical records. And let's say that the attorney then only got, like $1,000, whatever, whatever the 25%, back pay fee was. I'm not doing math. It's the morning. But the point is, like, all of a sudden the law firm just lost over $1,000 representing somebody who was fully found, favorable, fully found disabled. And now it's like, well, who's going to pay for this damn medical record? And then the law firm had to say to the claimant, okay, well, you have to pay this medical facility back, or us, because we paid for it originally, over a certain amount of time. It got bad. It was just a bad thing. So HHS came out with a high tech that you could only charge like $6.50, $10, whatever, $15 to go ahead and request the records digitally. So it wasn't $1 per page. It was way cheaper, right? But here comes Commissioner Saul, where they were saying, okay, guys, now we get that a lot of you are saying that they're not participating in this whole high-tech situation. And remember, there is an entire industry. If you look at like ScanStat, you look at any one of these groups, that is a multi-billion-dollar industry of taking your medical records and then charging you a ridiculous amount per page to get them back from the medical facility. They are like ticks. They get into a medical facility. It's disgusting. They start sucking off the blood off the medical facility. And then basically they're sending out these records, making buku money off of people who don't realize that they can request their records with a simple high tech to go ahead and get them far cheaper than having to pay $1 per page. HHS had to go after quite a few of these individuals because the medical facilities were not playing ball with the new rules. They even sued them. SIOC sued them. Frankly, had better attorneys. I read the brief multiple times than the federal government had. And, it's one of those things where we'll go another 5 years and then we'll get another HHS ruling. But that's the thing, it's that multi-billion-dollar industry of taking your medical records and then selling them back to you. It's disgusting. It's double dipping. Like, think about it. Like, you go to the doctor, you pay to the doctor, you don't expect to have to pay. And sometimes the records were more expensive than the doctor's visit. That's the definition of double dipping. It's like, come on, guys. So, anyways, at the hearing level, a claimant generally must submit or inform us about written evidence at least 5 business days before the date of the scheduled hearing. So, what was born from the Commissioner Saul era was the 5-10-day rule for hearings. And they were like, look. You've got to tell us within 5 days before the hearing if there's any outstanding medical evidence, right? And everybody's like, okay, fine. We'll tell you 5 days before. And the reason they did that was they wanted to know, okay, this is what we're waiting for. This is what's coming up. This is what's going to be over on the horizon as we're doing the hearing. The 10-day rule is basically you have to submit any medical records that you have 10 days before the hearing. 5 days before the hearing, you got to let them know if there's anything outstanding. That's the 5-10-day rule that was born during the Commissioner Saul era. All right, next one. We adopted this 5-day requirement because of the workload challenges. As we explained in the preamble to our notice of proposed rulemaking, we cannot afford to continue postponing hearing proceedings because the record is not complete at the time of the hearing. And so they became very crusty and cranky at the hearing office because the thing was this. If you postpone 70% of the hearings by 20 days, it's massive. It is massive, right? Now, what's ironic about this is that back in the Commissioner Saul era days, like the SSA wasn't in full blanking crisis mode. It wasn't in like the world's going to end mode like it is right now. So, to their like red blinking light mode, that was nothing. That was nothing compared to how it is now. But you can see they made these aggressive changes to be like, yes, we are not the primary, duty people. You're the primary duty people. We're the secondary duty people. And they put it in writing just to go ahead and clarify that the duty of the SSA to assist is really more like not so much a promise, more like we'll try when we can, and that's that wouldn't happen in VA land. Like in VA land, that wouldn't happen. All right, next thing. A representative's duty to submit evidence is derivative of the claimant's. I'll do another video on that. That's an important sentence there. Derivative of the claimant's. However, representatives must also follow rules of conduct and standards of responsibility for representatives, which means representatives have to know the rules. Claimants, they don't have to know the rules. Representatives have to follow the rules. Claimants aren't never going to be able to follow all the rules. Those rules impose an affirmative duty on a representative to act with reasonable promptness to help obtain the information or evidence that the claimant must submit forward the information or evidence to us as soon as practicable. A representative also has an affirmative duty to assist a claimant in complying as soon as practicable with our request for information or evidence. The ruling explains the request to submit or inform us about evidence and clarifies who has the final responsibility to obtain written evidence. So here's the deal. Just so you guys understand where this whole thing is going. Social Security disability attorneys, we make hardly anything on these claims. It's not good. The VA claims for disability, those attorneys make a lot of money per claim, right? And that's how it should be. Like a lot of people are like, oh, no, they should make little money like they do with SSA land. No, and here's why. We don't have, as Social Security disability law firms, the amount of money we need to hire all the different people to do the different functions required for your claim at a very high level. We don't. There's no way we could do it. And think about it. When you're like, okay, so this disability attorney took the claim. They were working on the claim for, let's say, a year and a half, and they made, let's say, $1,700 on that. How would you afford enough people to do all the communication required, complete all the paperwork, buy all the records on $1,700 for that period of time? Like if somebody said to you, hey, I need you to clean that floor once a week for, which is like, checking on the claim, see what's going on. So once a week for basically, let's just say 15 months, right? 17 months, whatever. That person, right, a custodial person would say, hell no, absolutely not. I'm not doing that for that amount of money. That's way too long a period for way too little money. But yet disability law firms are expected to clean that floor once a week for that amount of time for hardly any money. So the problem is disability attorneys, in the Social Security, the civilian side, they make way too little. So like this heightened standard of writing like superb briefs and doing this and doing that and blah, 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 blah. It's impossible. There's not enough money. There's not enough money to do it. Like there's just not. You could take the biggest disability law firms out there. And here's the thing that you should know, which is really interesting about this field. Just this is like a little secret of the field, just so you know how it actually works. The disability firms that keep buying other disability firms are not SSA civilian firms buying other disability firms. They don't have the money to do that. The disability firms that are buying all the other little disability firms that are out there are the VA firms, because their claim or their attorneys make like, $20, $25, $30,000 per claim. Whereas us, for that same situation, would be making $5,500, $6,500, $7,200 for that claim. Now, obviously, if you're making $25K off of a claim for those benefits, it's a different situation because you can then afford staff to handle things, have more time for the attorney to stand back and write the briefs and things like that. Whereas with the civilian SSA version, the attorney is like in the trenches doing the work, right? There's no like overseeing it. There's none of that. It's in the trenches doing the physical work. So there's no like, they don't have, and you can keep hearing my phone ring. And that's because these are calls that are assigned to me from, the person in back office who's got too many calls coming in. So then I've got to take them, so, they have the ones they're on, and then I get assigned calls, and then another person gets assigned calls, and we have to answer those and keep going through them. So the disability attorneys are in the trenches in the civilian side, not so much, or they're just not on the VA side. So anyways, let's go through this real quick. All right, here we go. Statutory provisions. In general, an individual has a statutory obligation to provide us with evidence to prove to us that he or she is disabled or blind. The Act also precludes us from finding that an individual is disabled or blind unless he or she submits such evidence to us. So that's important. The Act also precludes us. Like the SSA will not find you disabled. Okay. Will not find you disabled if, for example, that individual hasn't submitted the evidence to them. So I'll read it to you again. The Act also precludes us from a finding that an individual is disabled or blind unless he or she submits such evidence to us. I'm going to go ahead and put this thing on real quick. Hold on. Let me just get rid of this. Perfect. Okay, cool. So here's the deal. Let's go through this real quick. The Act also provides that we shall consider all evidence available in an individual's case record and shall develop a complete medical history of at least the preceding 12 months for any case in which a determination is made that the individual is not under a disability. In addition, when we make any determination, the Act requires us to make every reasonable effort to obtain from the individual's treating physician or other treating healthcare provider all medical evidence, including diagnostic tests necessary in order to properly make such determination prior to evaluating medical evidence obtained from any other source on a consultative basis. So you can see where they're like, really squeezing this thing down to say, hey, we only have this duty, and it's really just a secondary duty, and the primary duty is on you, the claimant, and whoever you chose to be your attorney. Next thing. Thus, although a claimant has the primary responsibility to submit evidence related to his or her disability claim, okay, sorry, I went through that a little bit before. All right, so with that said, okay, I'm going to know. Here's the important one. Thus, although a claimant has the primary responsibility to submit evidence related to his or her disability or blindness claim, the Act also gives us a role in developing evidence. Our statutory responsibility ensures that we develop a complete 12-month medical histories, right? That's that whole 12-month thing where they're going back from the date you file, or if they think it's farther back or you think it's farther back, they'll do 12 months back from that, right? That's the requirement. So if you're like, I want 2 years back from this, blah, 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 they don't have that. Their minimum, which is their standard, is only 12 months back. Okay. Okay. History. When we make a determination about whether an individual is under a disability and to make every reasonable effort to obtain from a claimant's treating sources all medical evidence that we need to make a determination before we evaluate medical evidence from a consultative examiner, does not, here's the important part, however, reduce the claimant's responsibilities in any way. So they keep coming back to this whole, the claimant is responsible, the claimant is primary, the claimant has to do these things. Whereas in the VA side is like, look, we get it. You just probably came back from war. You probably just came back from service. We have the grand duty to go ahead and assist you with developing the claim. And what's interesting is the VA people will be like, oh, they didn't do this, or oh, they didn't do that, or oh, the claim, the thing that you'll see like all over the internet is they'll be like, those VSOs, oh, those VSOs don't do anything, and those VSOs da 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 da. But it's far more than what you would ever get from the civilian Social Security side. Like, it's a shocker to a lot of these veterans who get their veteran disability benefits. And some of them have to like fight up the kazoo to try and get them, and it's like miserable. And then they go to the SSA side and they're like, oh, it's the same thing. But like with a lot of this stuff, many of these veterans go to the civilian side and they're like, what the hell is this? This is so unorganized. What is this? And they go through this like mental trauma of like, how could it be this bad on the civilian side? And, it is what it is. But anyways, let's go through this real quick. Okay. An individual's affirmative duty, and they're just going to hammer home with this writing right here. The individual's affirmative duty to provide written evidence. Let's go through it. Our regulations require an individual to submit or inform us about all evidence known to him or her that relates to whether or not he or she is disabled or blind. This duty is ongoing and requires an individual to disclose any additional evidence about which he or she becomes aware. This duty applies at each level of the administrative review process, including appeals council level, if the evidence relates to the period on or before the date of the administrative law judge hearing decision. All right, so we go through that. You understand the 5 days situation. You understand what's going on with that. Okay, there's a representative's affirmative duty. Let's go over here. While our regulations state that claimant must submit or inform us of all written evidence at least 5 business days prior to a hearing, our rules of conduct place additional requirements on representatives, as discussed above. Basically, number 1, they're required to act with reasonable promptness to help obtain information or evidence that the claimant must submit. Number 2, required to assist the claimant in complying with our request for information or evidence as soon as practicable. Number 3, prohibited from unreasonably delaying or causing delay of the processing of a claim without good cause. Or number 4, prohibiting from actions or behaviors prejudicial to the fair and orderly conduct of the administrative proceedings. Therefore, we expect representatives to submit to us or inform us about written evidence as soon as they obtain or become aware of it. It's impossible. An impossible rule. Imagine this. Let me tell you why this is an impossible rule. Another bullshit, Commissioner Saul rule that came out during that 2016, 2017, 2018 era. All right. Let's say that you go to hospitals and medical facilities all the time, right? So let's say you're going to medical facility A today. 3 days later, you're going to medical facility B. 4 days later, you're going to medical facility C. 2 days after that, medical facility D. Do you think we go ahead and notify the SSA every single time you go to a facility? No. We know where the points are where the records are being purchased, because it would be insane to have to request from the medical facility 30 times before a decision is rendered during these long wait periods to go ahead and obtain the evidence. That would be insane, right? Let's say you went to different medical facilities, right? 30 times over, that 10-month, 15-month, 20-month wait period. It would be absolutely insane to constantly pick up the phone and say, SSA, go get this record. SSA, go get this record. Now, when we come to the pinch point where we know a decision is going to be made in the not too distant future, and this is the point where evidence is supposed to be collected, that's where we go, okay, cool. Here's all the facilities. Here's all the stuff you need. Go ahead, send out your 827s to this one, this one, this one, and this one, right? And get all of them. Here's all the medical facilities, right? We get, and then we say, okay, go ahead and just collect them all, because then you just have one record for all those visits during that period from that medical facility. But this standard, it's just bullshit. It's a bullshit standard. It's another bad rule that was made during the Commissioner Saul era, which I thought, to be fair, when President Biden got in, because I was thinking, because he was a Democrat and because very liberal, and I was expecting them to roll back a lot of these Commissioner Saul rules. Did they roll them back? One was rolled back, and it wasn't even a relevant one. It wasn't even like it was like the whole, like, can they do a CDR at 2-year intervals? And they were like, well, we're going to roll that back. And, oh, it's super important. Oh, look what we're doing. They can give you a CDR at 1 year, 3 years, 5 years. It didn't matter. It didn't matter, right? It was just it was like a way to advertise that you're doing something, but you're not actually doing anything. So the point is that I'm getting out with this particular thing. I thought they were going to roll back a lot of these rules that are total BS, like that just from a practical standpoint don't make sense, that don't work. They never did. In fact, some of them, they tightened it even farther down to put more emphasis on the claimant having the requirement to do things. So anyways, and a lot of people I know in the chat are always like, well, how the hell did you not know, that President Biden was going to be this way? Did anybody like realistically? I mean, we knew that, he made comments back in the day that he wanted to end Social Security, but he never had any power to realistically do that back in the day. He doesn't have any power to do that nowadays. So did we really, you know what I mean? And I can always see now that, and the other side is there'll be somebody in the chat section or the comment section being like, President Biden is the child of my great son. There's my baby, and we go through all that too. Like, there'll always be somebody in the comments that's like, this is the best economy we've ever had. And I'm sitting here like hearing stories every single day from my homeless claimants about like how they can't afford a soup can at their local grocery store. Like, it's there's like this weird, I don't know what it is. I used to think people had like a little blanket over their head that they could like see through a little bit about their political party person, where they like, they just believed that their political person was like, they wouldn't do that. They wouldn't do that, right? They would go through this mental, like, no, not my little Billy, not little Tony, right? They wouldn't do that. And then what I realized was that it's not just a blanket with large woven fabrics that you can kind of see through and be filtered from. It is a heavy military style, giant lead-filled blanket where you don't care. You just think they're awesome. And no matter who they are, doesn't matter which side, Democrats or Republicans, doesn't matter which candidate, you just think they're friggin' super dude. This was a Trump era policy. Okay. Just to clarify things. All right, here we go. Pursuant to the act, we may, after due notice and opportunity for hearing, suspend or prohibit from further practice before the commissioner a representative who refuses to comply with our rules and regulations or who violates any provision for which a penalty is prescribed. Right? So they're gonna stomp out any representative that doesn't constantly give them satisfying updates as to medical documentation. All right, so we've gone through this. A lot of this continues to just repeat itself. 5 days, you got to give them a heads up. 12 months, they'll go back. If we see a violation, we'll report it to OGC. It does not change our duties with respect to the development of the evidence. The point is, what the SSA did was they stood back and they said, you know what? We don't want the primary responsibility because we want to always be able to say the claimant had the duty. And you would never see that. You would never see that shit in VA land. You would never see that. In fact, the VA celebrates, although they sometimes fail at it, they celebrate the level of duty that's owed to the veteran. So Anyways, I hope you guys enjoyed this video where I go through a policy interpretation from the Trump era via Commissioner Saul. And I know some of you really love Trump, some of you really love Biden, and that's fine. I totally get it. But you have to understand, I'm a practicing disability attorney in the field. Like, I'm a disability attorney that's doing it every single day. After this video, I literally go to answer calls and work on claims. So the point here is, I just hope you understand that I live through like having to step into that mud pile and then have to walk through it every single day. And so as a result of that, I don't see it as like the red guy and the blue guy and the this person and that guy, did super well by us. I see all the shitty things that they do and require and change and propose and then have to live through. So, it's a very different, like my guy wouldn't do that. It's very different. They did. This is what they did. And now I'm stuck with it. And now it ruined my industry, And some people be like, well, I don't think, a 5-10 day rule is really that bad, or I don't think blah, blah, blah. The big picture here, what you got to collect from this is that this was an interpretation to tell everybody that the SSA was not going to take up the standard of the VA for its own effing citizens. Like, does that bother you? Does that bother you to realize that they're announcing to the world that Americans who are disabled have to have the primary responsibility, right? When it comes down to, basically telling them about documents, making an attempt to go ahead and obtain documents and da 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 da. If they're disabled, then they're obviously not operating at 100%. Not that anybody ever really is, right? I'm tired this morning. I'm not 100%. But the point is, like, does it make sense that a civilian, an American civilian, should have the primary responsibility of developing their medical claim, or should the primary responsibility sit on the shoulders of the SSA? Granted, they're not going to know, and they should have spent a lot more time back in the day figuring out how to get all the medical records onto a single server and then be able to go ahead and send requests to that server and then pull records from that server and have that server be handled by a non-government entity, right? Like a non-profity kind of thing. But they didn't do that. They're working on it now, but they're just, anyways, that's just my 2 cents. I know some of you are making dinner for President Biden and President Trump. Good. Good. Very good. Anyways, I will catch you guys later. I have to go do phone calls and we will go from there. I will see you tonight because remember, every Thursday night I go live and I answer questions on YouTube around 8 or 9 p.m., usually around 9-ish. So remember, there's rules. Use a fake name when you call in, 5 to 7 minutes, no story mode, have your legal question ready up front. Please remember to click that like button. There's only 55 likes on this video. There should be like at least 50 billion, Just kidding. It's not that good of a video, but the bottom line is you give it a like. Don't be stingy with the likes. Remember to subscribe. Thank you to all of our members here. I see Diana Fernandez. I see Anna, which is awesome. Very cool. Very cool. Now, with that said, if you want to leave a review, this right here, disability resolution. You think I know how to say it. I've been working there for over 10 years. Disability resolution. You just go to Google, type in disability resolution law firm. You can leave a review, basically disability resolution Florida or disability resolution law firm. It'll pop right up. Other than that, I will catch you guys a little bit later. You have a wonderful, wonderful night. And I will see you later tonight to go ahead and do a couple more videos. Thank you so much. And we'll catch up later. All right. Thank you. Bye-bye, everybody. Bye-bye.